Namaskar, I am Santanu Mondal. Today I am giving presentation on one of the important topic of the law of the contract, that is consideration. Consideration is defined under section 2 clause D of the Indian Contract Act 1872, which states, when at the desire of the promisor, the promisee or any other person has done or abstained from doing, or does or abstain from doing, or promises to do or to abstain from doing something, such act or abstinence or promise is called a consideration for the promise. Here in this definition, meaning of some words are very important. Desire means demands of the promisor or the wants of the promisor. Abstain means something not to do. The phrases has done or abstain from doing means something previously done or not done in past. Does or abstain from doing means something to be done or not to be done in present. And the phrase promises to do or to abstain from doing means something promised to do or not to do in future. Now, if we break down the words of the provision, then consideration is something which is given by the promisee or any other person according to the desires or the demands of the promisor, or something which the promisor regards as consideration, which was previously done or not done, or to be done or not to be done in present, or promise to do or not to do something in future, such acts or abstinence, irrespective of done in past or to be done in present, or promise to do or to abstain from doing in future. This definition gives some essential of a valid consideration and types of consideration as well. Firstly, desire of the promisor, that is to say, consideration is something which the promisor demand out of his own to perform his part of obligation. For an example, if a promisor want a specific radio, then the consideration must be that specific radio, not any other one. Secondly, it must be real. Let's say a son is claiming to his father that his brother has been given more property than him. His father said if he stopped complaining, then he will release his son from a debt. It is not a real consideration for a valid contract as held in the matter of White versus Bullet, 1853. Now coming to the types, it may be past or present or future. In case of past consideration, there is a rule that it will not be consideration unless the promisor accepts the past work as consideration, and it must be involuntary in nature. That is to say, it must be non-gratuitous in nature. Otherwise, it would not be a valid consideration and the contract will be void under section 25 of the Act. There is another rule of non-existence of a legal duty. Something promised for the consideration, something promised as consideration in the exercise of a legal duty is not a consideration. Otherwise, it would lead to corruption in public matters. Thank you.